Ladies and gentlemen, my name is Denny Brennan. I'm the Executive Director of the Massachusetts Health Data Consortium, and I want to welcome you to today's webinar with Graham Dufault and Act Online. The purpose of today's webinar, Graham will get into the world of privacy, the world of data and how it's handled is a complex world. It's not, for those of us in healthcare, strictly limited to the world of HIPAA and how HIPAA evolves over time. It's actually much more complicated. Those of us in Massachusetts are aware of some of those complexities, but at the policy level, and as we look at the proposed and final rules from CMS and ONC that essentially place the consumer, the patient, the member at the center of their own health data system, or as a colleague of ours would describe it, an HIE or health information exchange of one person. That's the world we're evolving to. The regulations referring to data being owned by and belonging to the consumer are in the books, as are a number of requirements that consumers have the ability to use an app on a smart device or apps, multiple apps for that matter, to control who and under what circumstances has access to their health information. That's a simpler than reality portrait. And Graham's going to share with us, based on his experience, just how complex and ever-changing that world is. By way of Robert's Rules of Order in the postmodern digital age, a couple of notes for those who are attending. One, if you have a question, by all means, place it in the chat room, raise your hand or interrupt us. We like questions. They keep us honest. They get to some of the issues that we may not cover directly. And engagement is always a good thing. Secondly, we will have copies of the presentation available for those of you who don't have a copy and would like to have one to take with you, and we will make those available shortly after today's discussion. Lastly, for those of you who don't know the Massachusetts Health Data Consortium, we have been around this is our 44th year. I was looking back at some of our earlier materials, and among the topics we convened membership to talk about and discuss and to determine how best to deal with as a new technology was the internet, which is an interesting and somewhat humbling realization that yes, there was a world before the internet. There was a lot going on. MHDC would carry tapes from different health systems in order to compile data as we did in the past, but we are a membership organization, and as a not-for-profit, we value members, and we would love to have those of you who are not members to join our consortium. And we look forward to providing more of the services, much like we're offering today, throughout the year. We anticipate having between 24 and 30 plus webinars this year. Members of our consortium at the executive level have access to our CIO forum, which will meet 8 times this year. And if all goes back to a reasonable state of normalcy within a reasonable time, we will have an annual meeting. I haven't slain the dragon of doing an annual meeting on a webinar yet, and I don't know if I want to fight that battle. But we will be getting back to some of the membership activities that we've always done. We also have a data governance collaborative that convenes the major health plans and providers in the state to collectively and systematically meet the requirements of the proposed rules with respect to information blocking, interoperability, as I just discussed. We are standing up a real-time prior authorization demo, or prototype is a better way of describing it, consistent with the Da Vinci implementation guides. And we are doing a number of other activities with respect to helping organizations navigate the path between now and 2024, when everyone is supposed to be communicating with everybody else consent and privacy issues certainly in consideration, but for a completely different world than we have today. So without further ado, I'm going to turn this over to Graham Dufault. Graham, thank you for joining us today, and I'll let you take it from here.
Excellent. Thank you, Denny. And I will try to do this while I am talking, but I'm going to share my screen here and then change it to slide mode so that everybody can see the slideshow as I am progressing. Okay. Wow, it worked. Okay. Does everybody see that? I think everybody sees that.
Yes, we do.
Oh, excellent. Well, thank you, Denny. Thanks to Arlene and Lynn for inviting me to participate and to present our perspective on what's going on in the privacy policy space. You know, how all of the shifts in privacy requirements that are being proposed, that have been recently adopted, sort of affect the processing collection of health data. My background is my most recent job before joining the App Association is that I worked for the House Energy and Commerce Committee, working for the Consumer Protection Subcommittee. And so there, it was a bunch of different consumer protection issues that we were dealing with, but also one of those issues was privacy data security, and specifically privacy and data security as it applies to anything that's under the FTC's jurisdiction. You know, as we had the consumer protection half of the Federal Trade Commission. And we'll get into that a little bit more as we get down the road, but that gives you a sense of, you know, my background really being in consumer privacy outside the healthcare context. And so that's kind of how I'm approaching this. When I joined the App Association back in 2017, very quickly started to get into health data privacy and healthcare issues more broadly, because we have the App Association has about 5,000 members. They're software connected device companies, but increasingly they are getting into digital health services, and they find themselves, you know, some of them are under HIPAA, some of them are under the FTC and state law regime, and so there's a lot of questions that come up for them, as I'm sure questions have come up for folks in the audience around, you know, what set of laws applies and when. And so some of that we'll get into. But generally, you know, the structure here is just to talk a little bit about federal law, what's the current federal law. I think there are going to be a couple of things that continue to recur throughout the presentation, which are that in the US, we have a very separate regime and framework that deals with health data privacy than for the rest of the economy. And then that includes the other frameworks that exist for financial services privacy, education privacy, and then there's like a subset of laws dealing with children's privacy. And so that's generally kind of the backdrop at the federal level. And then we'll get in a little bit into state proposals. California is the main one that I'm thinking of, because they're the state that has enacted a general privacy law that is comprehensive. And then I was going to talk a little bit about Washington, because that's a proposal that other states are starting to copy. Other states are also, including the Massachusetts legislature, considering legislation based on the California model. So the other competing model appears to be Washington. And then there are even another couple of categories of state legislative activity, like the ones that you see in Utah and other states that don't really fit either mold. And then I was going to talk, just for further context, a little bit about GDPR, not too much. So Europe's General Data Protection Regulation, just to give us a little bit of a different perspective on, you know, and what is informing Congress's activity, and how Europe is quite different from the US when it comes to fundamental approaches to privacy. And then the federal proposals. So what are the congressional committees doing? What are our members of Congress who are active on privacy? You know, what are the proposals that they've come up with and that they're considering going into the 117th Congress? So we already have a bunch of chats, but I'm going to move this over here. Let's see here. It's not in full presentation mode. Oh, okay. Sorry about that, folks. Is this okay though? Lynn, is this okay?
It's okay. I was just going to say, if you go under display settings there, you can get out of the presentation mode and go under fold. Yeah,
There you
duplicate
go.
slideshow.
Swap that.
Or swap, yeah. Either or, yeah. It will go to the full screen, full screen.
You would think I know how to do
There
this.
There we go. Perfect.
I am so sorry, everybody.
No. I mean, I could see it. It wasn't bothering me, but I know it might be a little bit of a eye test for some.
Excellent. Okay, thanks. Thank you for the help there. That's awesome. Okay, so we got this. All right. So moving on to the first slide here, if I can do that. There we go. Why not start with HIPAA? I know that many of you on this call here are going to be intimately familiar and know a lot more about HIPAA than I do. But just to set the stage, the Health Insurance Portability and Accountability Act is the law in the United States at the federal level that applies to healthcare organizations. I think it's notable that in the U.S. We separate healthcare privacy by the type of entity. So it's a covered entity or a business associate to which HIPAA applies, as opposed to the healthcare data that they are processing per se. Yes, there is a definition of protected health information, but the main touchstone is if you're a covered entity or a business associate, then you have to be worried. So covered entities are providers that process insurance claims, health plans, clearinghouses. Business associates are vendors that have the contractual relationship with the covered entity, and BAs are required to comply with HIPAA via those contractual provisions. But they are also, they're liable to the U.S. Department of Health and Human Services through its sub-administration, the Office of Civil Rights. So that's an interesting arrangement, and it definitely separates us from the Europeans, for example. And it sort of mirrors what is going on at the state level as well. So there's the privacy rule and the security rule. In general, the way I think of privacy is as a public policy issue is what are the means by which an entity is required to gain authorization to engage in certain processing activities. What can they do under color of that authorization credibly? And then security is more about what safeguards do you have to implement to prevent unauthorized access to whatever data is covered. And so increasingly, I think one of the themes that we'll probably talk about today is that it's getting a little bit harder to distinguish between security and privacy as the types of processing activities get more complex, and what companies or covered entities have reason to say is being done under color of authorization sort of expands. And so later on we'll talk about an enforcement action by the FTC, for example, where the minority on the commission dissents and says we should have enforced our data breach rule in this privacy case. So we'll move on to the next thing. Only reason I wanted to bring up the information blocking rule is that it is a very important development in terms of what we're going to see happen over the next couple of years, I think, which is that the whole purpose is, as Denny put so articulately, is to enable the patient to be their their own HIE, so that they can access their own data, they can put it to beneficial use on behalf of their own health, and some of that is going to require the ability to request that data and then transfer it outside of the HIPAA covered umbrella, so away from covered entities, away from business associates, and into this sort of world of consumer health or wellness. So rightfully so, EHRs and others have raised the concern, well, if a patient is requesting this data and we have to facilitate its transfer to a third party. So a diabetes tracking app or something like that. That's not one of our business associates. It's outside of our orbit of control. Is the patient then going to blame us for a security lapse that this potentially fly-by-night company has, or some shady privacy practices that they engage in? And so the way that information blocking rule tries to deal with that is to say that, well, if you're an EHR company or provider that is providing access to this data, then you can communicate with the patient and communicate the privacy and security risks with the patient as they are making that request. And that you can require a third party to attest to taking certain security and privacy measures. I think it's a 2,000-page rule or something like that, but it's in there. These allowances and these abilities for covered entities and business associates to provide that additional information. And so it does a couple things. It both enables the patient to make sort of a better informed decision about, do they really want to share that data with a third party that is not under HIPAA? But it also requires an entity that's under the Federal Trade Commission's jurisdiction to make a disclosure that makes it a little bit easier for the FTC to bring an enforcement action. And I say the FTC, but I'm also talking about state attorneys general, for example. And we do have a great question from the Q&A box. How can consumers best make sure of the privacy and security practices of a healthcare app? It's a difficult question when you're looking at apps that are not under HIPAA, right? So there are, there's a couple ways of doing that. Any app that's on the Apple App Store or the Google Play Store should have a privacy policy. Apple is just rolling out, for example, a privacy nutrition label type arrangement where it is providing sort of box checking information that's supposed to be sort of standardized across different apps, that helps you better compare between apps and the privacy and security features of apps as compared to each other. That's a powerful thing, and that's being done at the platform level. We always at the App Association we always point to the ability for consumers to look to the platform to provide better privacy information about apps, because it's user friendly, and it's sort of in a standardized format, and it better enables comparisons, lends itself to comparisons a little bit better. So that's one way, is through the Apple App Store, the privacy nutrition label thing that they are now rolling out, and I think it's iOS 14. But then there's also a couple of different privacy best practice efforts that have taken place over the last few years. There was an effort called, let's see here, I think it was called Haptique, which then kind of transitioned into Exertia, and that was a set of best practices that was developed. We actually contributed to the development of those best practices on privacy, and so if an app has an attestation saying, hey, we used the Exertia best practices, then that at least they were developing their app from the beginning with privacy in mind and using the suggestions from the best practices in that document. So there's Exertia, there's the platform level privacy disclosures, and then of course, if it's a third party that is receiving protected health information pursuant to a patient request under the information blocking rule, then you will have those disclosures that should sort of pop up as you're requesting that information. I'm not sure how that looks visually, but that's the theory in the rule, I think. We have more chats. Let's see, that's a really long one. Let's see here. What are the requirements that providers have to ensure that they are meeting this rule? Is there a need for a third party such as independent consultant to provide services to guide here? Yeah, that's a great question too. I think there's definitely a role for third parties to provide independent reviews of privacy practices and of security. So that's something that the market will probably develop. There is also a requirement. You'll see this in congressional legislation that we're going to go over later. There are requirements for independent reviews of privacy practices in those bills. And those are bills of general applicability that extend beyond HIPAA that the FTC would enforce. And so it would apply to all entities and not just those that deal with healthcare data. But as far as what are the requirements that providers have to ensure that they are meeting the rule, that I am not as clear on the details of what you need to show in terms of a provider. But we can happy to come back to that if folks have the answer or happen to know. So adjacent to HIPAA and the federal law that governs all of those third-party apps and services that would be receiving this data on behalf of patients, that's the Federal Trade Commission Act, which deals with both antitrust and consumer protection. What we're talking about here is the consumer protection half of the FTC Act, of Section 5 of the FTC Act, which prohibits unfair or deceptive acts or practices affecting commerce. Its shorthand is UDAP. And there are many FTC acts, just like there are many HIPAA laws in the states that sort of go a little bit beyond HIPAA, but don't conflict with it. You have many FTC acts that sort of mirror what the FTC Act does at the federal level. So they generally prohibit unfair, deceptive acts or practices. That's a really broad prohibition. But the critics of the FTC Act as a privacy enforcer will quickly point out that there is no civil penalty authority for the FTC for a first violation. And so it's relatively toothless when you compare it to OCR's ability to fine you for a privacy lapse. I'll take for one example, in a recent enforcement action against the Flow app, FLO. It's a period and fertility tracking app that had 100 million users, which is amazing to me. But one of the things they were doing was, their disclosure said, we're not going to share your data with X, Y, and Z. But they actually, when their actions didn't match up with their privacy policy, and so the FTC brought a deception case. So it was the deception prong of its UDAP authority, which is the most common type of FTC case involving healthcare data or any other kind of data. So it was the FTC is composed of 5 commissioners and all of their staff. They voted 5-0 to approve the settlement. It's usually an FTC case. They have a draft complaint, they bring it to the company, and then the company and the FTC come to a settlement. And so the settlement basically says there has to be independent review of what the Flow app, are doing with data to ensure that you're being compliant with everything that you say you're doing. You have to get explicit consent for sharing in the way that you're sharing. And then if you violate this consent order, then you are liable for civil penalties up to $44,000 per record, per violation per day, which can really add up. It's a big civil penalty authority. It's that capability. It's the ability to fine a company that violated its own consent order that enabled the FTC to fine Facebook $5 billion. The FTC, it enforces that really broad unfair, deceptive acts or practices law. It doesn't have the statutory authority to draft rules under it. unless they use quote unquote Magnuson-Moss procedures, which are just too complicated, according to the FTC, to use, and they are very complicated. The other alternative is that Congress just gives them narrow rulemaking authority using the Administrative Procedure Act, which is what all the other rulemaking agencies have the ability to do. And in this case, Congress actually did give the FTC limited rulemaking authority to draft rules around health breach notification. So in other words, if you are a certain kind of company with a certain kind of data, and you have a breach of that data, unauthorized acquisition of that data, then you have to notify the consumers that are affected without unreasonable delay, and in no case, no later than 60 days after discovery, which matches up with a lot of state laws, and including in the healthcare context. The rules were finalized and went into force in 2010, and they've never been enforced. So the two Democratic commissioners in the Flo case partially dissented, even though they voted in favor of the settlement, saying we should have enforced the health data breach notification rule, because even though they were pretending like what they were doing was authorized by the consumer, and they did it on purpose, that was unauthorized access to that data, which is it's an interesting, it would be an interesting application of the breach notification rule. But now that we're going to have a Democratic majority on the Federal Trade Commission, we're going to probably start seeing a much greater appetite to enforce the rule, including in the context described within the Flo case. So that's something to watch out for. That's a trend that we're going to see more of, I think. So yes, the FTC does not have rulemaking authority really broadly, but it does. What it does is it pushes out guidance. It points to old consent orders, and it says, may this be your guide, going forward. If you're a small company, for example, you have no idea how the FTC is thinking about edge cases, look at the consent orders, and then also look at these guidances, which are linked here in the presentation. So not a very developed approach, honestly, at the federal level to healthcare data that leaves the HIPAA covered umbrella. But I think federal policymakers, lawmakers in Congress are starting to awaken to that, and they're starting to try to do more to address it. For a lot of different reasons, I don't think it's going to fundamentally be different. I don't think it's going to suddenly take the European approach and put all healthcare entities under the same privacy regime as the rest of the economy. And we'll get into the reasons for that, but they're going to try to do a little bit more to ensure that the FTC is better equipped to handle cases like the Flo case. With the state level activity, we're seeing kind of a mirror of what the feds have done, are doing. The California Consumer Privacy Act, it's the first comprehensive state privacy law of general applicability. It is not the primary regulator of healthcare privacy or healthcare data in California. That is the CMIA, which is, I describe it as a mini HIPAA, even though it doesn't really mirror HIPAA. It just sort of adds on to HIPAA. It goes a little bit further than HIPAA, and it doesn't conflict. And so as a result, it is in force, and it is the state level law dealing with patient information. So CCPA does apply sometimes to even to covered entities, and that is where BAs and covered entities are processing non protected health information like website browsing, advertising data, then they could be subject to CCPA. So as a result, some of the carve outs in CCPA really do matter. If you're not carved out of CCPA, you're under it. And de-identified information is one of those areas where the drafters of the law tried to carve out de-identified information. Unfortunately, they initially did not tie it to the definition of de-identified information under HIPAA. And so there was a lot of confusion around, that sliver of data that people were de-identifying under HIPAA that maybe also would be under CCPA and therefore subject to the consumer rights and all the other aspects of CCPA. So very quickly, this was done by ballot initiative in November last year. Was adopted the California Privacy Rights Act, which amends CCPA, makes a bunch of updates. Relevantly here, it clarifies the exemption for de-identified information, tying it directly to HIPAA's definition. And so hopefully just clearing up that ambiguity. It adds a couple of additional requirements so that you have to publicly commit to not re-identifying that data and then contractually requiring any downstream recipients of that data not to re-identify that data as well. It also adds a definition of sensitive personal information, and you're going to see more of this with the congressional proposals, including personal information collected and analyzed concerning a consumer's health. So that's a set of data. It's a risk-based approach, right? It's subjecting data concerning health to stricter regulations, stricter requirements, and that's outside CMIA. So that's a sliver of healthcare data that's not held by a covered entity or a business associate or a healthcare provider under the California health data requirements. But that is subject to heightened requirements under CCPA. Healthcare apps like Flow, to the extent they're not BAs. And so there's a little bit more on anonymized and de-identified data. This is just to refresh folks on what are the couple of definitions of de-identified data. So under HIPAA, most researchers use the statistical method, which is where you rely on a qualified expert, using statistical methods that determine that there's a small chance of re-identification by an anticipated recipient. Researchers like that method because you're able to track somebody who's not identified, but a patient across providers or payers, and you don't have to know their identity, but you can still track them and attribute things to that individual, that number, that identifier. You've got the safe harbor method, which doesn't really allow for that, and so isn't as relied on by researchers anyways. So the use in practice is interesting because it's sort of, I think, what many of our member companies and others that we work with have noticed is that it's a little bit more difficult, increasingly difficult over the last couple of years to rely on the statistical method standard in HIPAA, just because the risk of re-identification goes up as the anticipated recipients have bigger data sets that in many cases they'll say, this data set is never going to be mixed with this other data set. And if it's patient data, we'll never mix it with this other data set that we control in our advertising business, for example. And yet, to what extent can you rely on that? And to what extent are there others that are similarly situated that are not making those promises? So it gets a little tougher to statistically say, there's a low enough chance that this data is going to be re-identified. Add to that the fact that even though HIPAA does not have a private right of action, which is a statutory provision that says an individual can sue for a violation of this act, state common law causes of action based in tort or negligence, often they are tied to regulatory statutory provisions like this, and that can be an opening for liability. that is, it's always an opening like this is where you'll see sort of entrepreneurial attempts to create, additional liability where none existed before. So I see Denny has the mute turned off. Did you want to jump in?
I did,
Yeah.
Graham. I have a question about this. We have experience with this in our own data
Okay.
analytics service, where we collect de-identified data from the state of Massachusetts for hospital discharges, ED visits, observation stays, and we have to go through a fair number of hoops
Okay.
to make sure that someone can't go back in there and using some of the techniques you described to re-identify that, yes, indeed, that anonymized patient at the Bay State ED was indeed George Clooney or whatever and I make that up. George Clooney has never been at Bay State as far as I know. So
Right.
that's a purely illustrative example. But more particularly, we are also seeing more data being described as essential to understanding how best to care for patients, including social determinants of health. It strikes me that when we look at social determinants, we get into an area where it becomes even easier.
Yeah.
When more information is attributed to an individual as a patient, including their socioeconomic status, their transportation, housing, food security, et cetera, this strikes me as a risk for patients, especially those who are likely least able to protect themselves from this, of being identified or of being having their information used in ways that they didn't anticipate. Can you comment on that a little bit?
That's a great point that you bring up. I think there is always going to be this tension between having this data available and usable toward the patient's benefit or toward the benefit of the healthcare system overall, and then the privacy of the patient to ensure that that data is not going to be misused. So the tension has been there, and it's worse now, I think, because we are developing all of these really interesting ways of accounting for social determinants of health and informing public policy so that we are providing for equitable healthcare access. A lot of that just kind of requires the ability to make use of that data that could potentially re-identify somebody. I have no answers on that. I just think that it's you put a great perspective on what that balancing act has been and will it will continue to be in an even more severe kind of way, I think. So maybe it speaks to the need for better mechanisms to gain consent and quicker, easier ways of making patients aware of what the risks are, in order to to ensure that the consent is informed to the extent it needs to be. All of that those are all really tough problems to solve, but de-identified is not always the way, at least what our member companies have gone. But it is, I think in both cases you've got a balancing act and a lot more work to do to develop a really good means of addressing the risks and the problems that you're talking about.
Great, thank you. I have just one other question that's a corollary to that, which is we see a lot recently about large health systems anonymizing, de-identifying large volumes of patient data and working with organizations like Google to run artificial intelligence algorithms with the assurance to patients, to regulators, to the public that what they're doing is okay. But it does raise questions again about sort of whose data are they? Who do they belong to? And I think in some respects, anonymization is perhaps overused as a way to advance the utility of data beyond what might be considered truly appropriate. I'm not saying that this is an example of that, but Anonymization can be used to do a lot of different things. What are your thoughts or insights into, in a world of anonymized data, does it still belong to the patient? Does it still does the patient cease to have control over the disposition of their data after an organization has gone through what they describe as an anonymization procedure, or is that still in the gray area as we currently stand?
Oh, I mean, it is a very, very tough question. And it's the levers that you see being developed are all imperfect ways of addressing what you described as the problem. The way that, the ways that we have gotten behind, I think the ideas that we have gotten behind it, the App Association, are providing sort of meaningful sets of consumer rights that they can exercise in order to access, have the opportunity to correct, delete within limits, or restrict the sharing of healthcare or other sensitive personal information. It's imperfect because, in any of these scenarios, when you are talking about data that's been de-identified and is not being shared, for example, then you don't want to force the company to re-identify it and then provide the consumer to access the ability to access it necessarily. So as capabilities sort of are enhanced over time to re-identify somebody, maybe we need to, and I'm sure that there are efforts are underway to do a better job of de-identifying and create something that people can really truly rely on, given our current milieu of data on people exist everywhere. But I think there's, to your point, is there a property interest, or is there a ownership interest that people have in their data? Yeah, even if it's de-identified, I think to some extent there really is a little bit of a vestigial right to that data, to the extent that it can be re-identified at some point and used against them. I think the whole Robinhood situation is another example of where consumers maybe didn't foresee, or maybe we as a society didn't necessarily foresee the ways in which data like that would be, or trading data that consumers were generating, would be used against them to bet, for hedge funds to bet against them. So we're not going to foresee all of the harms, and so we have to maybe do a better job, especially in the privacy context, of approximating what those harms might be. Even though we never want to regulate based on I can think of a way that somebody could be harmed by this, then we would subject our economy to a very, very strict permission-based competition, and we don't want to do that either. Not with the broader economy. Yeah,
it looks like we have a few other questions that have come up on the heels of mine, so maybe we can go through those. It says, one is, once data is owned by a patient, it is up to the patient whom they share with, so privacy is under user control. That's a question from Naeem Hashmi to everyone. Any comments on, is it up to the patient whom they share with and privacy is under control? Well, I can certainly say from the proposed rules and the final rules, the answer to that is yes, the data are owned by the patient, if ownership is the right word. But Graham, any thoughts on that question, or others that are coming from members of our audience related to de-identification and anonymization?
Yeah, I agree. That is the purpose of the rule, is to make sure that it's up to the patient to make those decisions. The question, as we've learned the hard way, is always going to be, does the patient know what they're signing up for? Even where the company that's asking for the data, knows what they're going to do with it at the outset, but then situations arise where, with Cambridge Analytica, there arose some gray areas and some very unfortunate situations where data was shared in ways that were completely unexpected, I think, by the consumer. So it's up to the patient, to decide where it's going to go, and then there are all these gray areas around, what did I just get consent for, and will this type of sharing credibly be attributed to what I got consent to do? Let's see.
We've got, if organizations are using the data for treatment patients, let me go back a step because I think there's further ones. Do healthcare providers, acute care and laboratory providers have an affirmative duty to notify the patient of the right to limit data sharing, and to what extent does the concept of opt-out apply under new data sharing rules?
Let's see. I don't remember seeing an affirmative duty to notify of the right to limit sharing. If we are talking about the transfer of protected health information from a healthcare provider or an acute care or laboratory provider that is a covered entity under HIPAA to an entity that is not a covered entity or a business associate, that third party that is receiving the data is not under is not under an obligation to respond to a request to limit data sharing. And so that would, unless we're talking about California. California does impose such an obligation, and so it would be not a function of the info blocking rule. It would be a function of California law that obligation would attach.
If I could step in for a second, this is Janice Karen with MHTC. Most of the new rules actually, if you're talking about the new interoperability rules, most of them actually work on an opt-in basis. So there are exceptions to that. But for instance, if you're talking about the patient being able to get data into their third-party health apps, that's solely on an opt-in basis.
Mm-hmm.
And so is payer-to-payer data transfer. There's some question about some of the stuff in the new rule that's currently frozen, but so it really depends on what you're talking about. The CMS in particular seems to go more for an opt-in mode.
Mm-hmm. Which I think would make sense, because you're talking about getting authorization, on behalf of where you're talking about a request from a patient. You're going to want that to be an opt-in, I think.
Yeah, but you still need to be careful, and there are exceptions to that.
Yeah, true. Especially, including if it's been de-identified and you're partnering with Google, for example.
Right.
Caused a big stir. Let's see. Should we go to the next question, or?
Yeah, let's move to the next question. Let's see here. We have, if organizations are using data for treatment, payment, or operations, it can be shared. That's correct. That is true from Stanley.
Yes. Yeah.
That is indeed the case. Is there any consideration in Congress or Health and Human Services of revising the safe harbor given real risk of big data re-identification?
So my understanding, I have not heard of anything in Congress being developed right now around de-identification. I think, actually, scratch that. There have been discussions. I can't point to a specific bill. I also know that the staff that's been drafting, like the general privacy bills that amended the FTC Act, but are supposed to deal with healthcare data outside of HIPAA. One of the questions they've been asking us is, do you like the safe harbor at HIPAA? Should we mirror that? Should we do something different? And we still haven't really gotten into the details of that yet, but they're asking those questions, and they're trying to inform what to do about it outside HIPAA. But I think I would be surprised if they are not looking at that in the wake of Google.
We also have from Bob Dichter, raises subtly more important question: who actually owns the data? After all of these years, there is not consistent agreement to this critical question, irrespective of data being de-identified or not. I could say from our vantage point, Bob, that the new rules, the final rules, not the ones that are in sort of hold because they were midnight rules at the end of the Trump administration, but the final rules that were put into the Federal Register and are now the law stipulate in no uncertain terms that the data belong to the consumer. Now, stipulating that and making that actionable is a big change. But the idea of a patient-mediated health data system where my colleague Janice Karen, who just spoke, describes an example where if I, as a patient, want to get a second opinion, I don't want the second doctor to see all the notes and all the information that my first doctor gave me, because it would bias the second doctor's opinion. So how do I make data available to a second opinion physician so as to inform him or her sufficiently of my care and what's needed, but not to bias the situation? So we see that as in the law. Now we see how that will be manifested is something we don't know yet, but the idea of patient level consent to granular level data in their record for certain uses, and that consent residing with the patient, seems to be fairly well spelled out, albeit the path to getting there not as clearly spelled out. Graham, would you agree, or any thoughts from your end of the spectrum?
I agree, and it is an effort to sort of approximate full ownership. I think people talk about the property interests that somebody has in whether it's land or personal property as being a sort of a bundle of sticks, and like how much of the bundle does a person have of in terms of the property interests they have in their own data. And the sort of the difficulty that arises is that we generate a lot of data online right now. So how does an individual exercise their property rights in that data with respect to all of it, and in all of its different forms, and all the inferences that have been generated? Maybe those aren't included, or maybe they are in a property regime. Like if somebody were to enact a statute that says you have all these property interests in all of your data, the line is here, go. So then this market starts to develop where you're selling your data for a few cents here, a few cents there. And maybe a market would develop where there's a third party that aggregates your ability to do that and acts on your behalf. But having you just do it on your own as an individual would be tough. It would be really tough to do. And so there is an exercise in kind of approximating your property interest in the data, I think, is how I would describe it.
Yeah, this is Naeem. This also brings out the issue of property, and that goes along with the ownership, and all boils down to the constitution level. So like in GDPR in EU, is individual right. When right comes up, then the ownership comes up. And if you look up US in Constitution, there is not even one mention of word privacy. Only state of New Hampshire has a word privacy where person information is owned in the Constitution. Rest of the state's Constitution, nothing. The only thing in the Constitution is the Fourth Amendment, search and seizure, but that's mostly applicable to the civil on the government side of it. So as long as there is no constitutional level thing, it's very hard to really even define who owns the data. Each state have a different way of defining what owned by the patient or not. Most states, provider owns it, literally. They will, and HIPAA is basically mostly governed by the provider. It's a Health Insurance Portability Act, not Health Information Privacy Act. Very different. They get confusion, So virtually there is no privacy in the HIPAA if you look up literally.
It's true.
That's
Just
something,
about.
yeah, it's something we're reminded of here every now and then, that it is a portability. This is insurance data portability. And that's you bring up a great point, and it helps explain why the U.S. is where it is versus other countries.
I've been doing a lot of GDPR implementation, so that really brings down to part of that would be the California, and especially, here user right is very much is even privacy and security, the big difference. Security is basically how we protect, and the privacy is what's user defined, is what's private to them. And privacy policy is where the company defines how we will protect your information that you classify as a private. So there's a big difference between privacy and security, which is bundled together. Privacy is a lot more to do with what the user says, what you can expose to other, as compared to what typical our consent is. Literally no consent. It's our privacy policy, and we just have one big button say, okay, bundled and global. And that's really not the way you can manage the privacy. Otherwise, illusion, just a thought.
Just as a timekeeping reminder or note, we are just past the halfway point. You've been able to get through 10 slides, Graham, and I know you have more to come. So I want to be sure, folks, we have all your questions. We get a transcript from all the questions at the end of the meeting. So if we haven't been able to answer them in the meeting here today, we will work with Graham together. We don't want to dump them all on Graham by himself. We'll work with Graham together, and we'll come up with answers and get those out to you after the meeting. So
that would be great.
Let's proceed. And let's get you a chance to proceed so you can actually finish within the time we have.
Sounds great. But by the way, I really appreciate these questions because they are, I'm learning things here, and they're very helpful it helps me make it more useful for you guys. So I mentioned the Washington Privacy Act. This is not an enacted law. This is a proposal in the Washington legislature. It's very similar from CCPA insofar as it exempts protected health information under HIPAA. It exempts healthcare information under the Washington healthcare privacy law, which is similar to the California healthcare privacy law, and it additionally tries to take on exposure notification and contact tracing, because as the pandemic generated the need for us to engage in sort of more robust contact tracing at the state level, then Congress and the state legislatures were trying to ask, okay, well, if we really are going to leverage the smart devices in everybody's pockets, and we're using potentially location data and other personal information, not to mention the uploading of a verified positive test. This is all very sensitive information. So what are we going to do to ensure that privacy is protected when a lot of these app developers that are trying to create these solutions are not going to be under HIPAA, and they are going to be under the general privacy laws? So what do we do to try and address the privacy risks in a way that quickly reacts to those concerns? So the Washington Privacy Act tries to beef up the privacy requirements on exposure notification apps. Let's see. And there was a question. Let me make sure. Okay. Yes, insurance portability. Yeah. Okay. So that was another just comment in the chat. I just want to make sure I saw that before moving on. And so so what is Europe doing? And Naeem described a little bit about what's going on in Europe. They have the constitutional provision that says EU subjects have a right to privacy, and it's more than the right to privacy or the right against search and seizure in the U.S. Constitution, which only applies to government access. And so this has kind of set the baseline. This has set the standard by which congressional responses are being developed and state law reactions are being developed. You can start to see a little bit where California got its ideas from: the right to transparency, the right to object to further processing of data and transfer of data, and then all of the other rights. That's touchstone of GDPR number 1, the data subject rights, and touchstone number 2 is what are the lawful bases for processing. You got to get consent. That is one of the lawful bases. People don't often talk about it in these terms, but one of the things that was striking to me with GDPR was that it's a ban on processing data unless you have a lawful basis, and that's really remarkable, I think. And it's not just applicable to sensitive personal information, although there is a separate definition of sensitive personal information. So these are the lawful bases. One of them is consent. One of them is legitimate interest. Those are two of the main ones I think that companies are relying on. Healthcare data does have heightened requirements under GDPR. Naeem knows this much better than I do, but the level of consent is putatively a little bit higher, explicit instead of unambiguous consent. It's just a heightened set of requirements for being able to process healthcare data under GDPR. Just notably that it's not you don't have to be a covered entity. You're not a BA. This is the type of data. Oops. So closing out GDPR. What's Congress doing? I think a lot of folks kind of wish that Congress would just draft an overarching privacy bill that would, as somebody mentioned, deal with the potentially outdated safe harbor under HIPAA, deal with some other outdated aspects of HIPAA. We're not seeing that exactly, not to the level I think people might expect. Mostly we are seeing a lot of bills that fall into one of two categories. Number one, extending HHS's jurisdiction and extending HIPAA beyond where its current line falls, to cover things like the Flow app and other consumer wellness products, diabetes tracking platforms that maybe are not business associates have decided to go the direct-to-consumer route. So that's category one of bills that you're seeing in Congress. Category two would be bills that try to completely overhaul the Federal Trade Commission Act as it applies to privacy, and I call those general privacy bills. Sort of in the middle of all, and one subgroup of those would be the contact tracing bills that have been introduced in Congress. And those contact tracing bills are sort of a microcosm of the bigger fights with the bigger bills that we're seeing. So in the first category, the healthcare privacy bills that look at extending HHS. First one I'll mention is a bill by Senators Klobuchar and I can't read that. Hang on. Murkowski is her name, from Alaska. How could I forget Senator Murkowski from Alaska? So it is a bipartisan bill, and this would extend HHS's jurisdiction to apps and consumer devices by creating a task force of FTC, HHS, state entities, and then the rule would be due 6 months after the task force issues its recommendations. So this is HHS creating a rule that would sweep in a bunch of different companies that are not currently under its jurisdiction, under its authority. And I think that terrifies a lot of companies in ways that they're not scared of bills that would beef up the FTC's ability, because they're just more used to the FTC. They're more used to the consumer protection authorities. The devil you know, I guess. So it also, by the way, clarifies that the bill does nothing to HIPAA. It leaves it untouched. HIPAA is perfect. How interesting. I don't think that's what they're saying. They're not saying HIPAA is perfect. They're just saying they're not trying to update HIPAA. They're not trying to do anything to HIPAA. They're trying to require a rulemaking and extend HHS's jurisdiction beyond where it currently is, and to bring wearables and apps and healthcare apps under some sort of set of rules that's OCR driven, or ONC driven. Sorry. This is another one, the Smartwatch Data Act. This is aptly titled. This one's all about consent. It prohibits the transfer, sale, sharing, or allowance of access to consumer health information unless it's aggregated or anonymized to a domestic information broker or other domestic entity. And then there are stricter requirements for overseas transfer of that data. The exception to that prohibition is informed consent, or if the information is being provided back to a covered entity. This one's also an extension of HHS's jurisdiction. This is enforced by HHS as if it were a violation of HIPAA. So keeping with the theme of not doing anything to HIPAA, but extending HHS jurisdiction, that's what this would do. It would not update HIPAA. It would not do anything to folks that are covered by HIPAA. But it would bring under HHS's jurisdiction another category of providers, of companies. Yeah, it would be. It's not just smartwatches. It would be any device, any software that would be in the business of collecting consumer health information, which has its own definition. I just summarized everything here just to keep us out of the weeds, but the point is, it is more than just smartwatches. Even though that it's a clever title, I think they just wanted to draw some attention to what they were doing. And that's Senators Cassidy and Rosen. Cassidy is a Republican from Louisiana. Senator Rosen is a Democrat from Nevada. And Senator Cassidy is a doctor. Senator Rosen has a computer science background, and so they are they're a dangerous duo on these issues. This is the first of a set of contact tracing bills. So this would this is a really interesting one. It's Democrat only, and it includes as covered organizations under the scope of this legislation, state public health authorities. So it imposes a bunch of privacy requirements on state public health authorities as they are developing their contact tracing programs, and specifically when they are trying to make use of an app or other tech-driven tool to augment their contact tracing capabilities. So that's an interesting decision because first of all, the main committees that have jurisdiction over general privacy in Congress are the Commerce committees. By regulating what state public health authorities do, that pulls the bill out of Commerce's jurisdiction and puts it squarely in the Senate Help Committee. And the Senate Help Committee does have jurisdiction over HIPAA, but it doesn't have jurisdiction over the rest of privacy. And so that was seen as killing the bill's chances of being moved as a privacy bill. And yet it was felt, I think maybe maybe they weren't wrong about this, but it was felt that, like, if you're going to impose a bunch of requirements on the app developers, they're only doing what they're doing pursuant to the RFI from the state organizations. So you should tell the state organizations what to do, But by doing that, they are causing some jurisdictional issues. By the way, that sort of explains why we don't have this overarching privacy regime in part in the United States, as the jurisdictional boundaries between the Senate Commerce Committee, Senate Help, House Energy and Commerce, and then House Ways and Means, which has more healthcare jurisdiction than Energy and Commerce. So the jurisdictional fights are a real issue and explain some of the institutional limitations of Congress that you would think are overcome if you get into a new Congress, new leadership, but are not, because they're just institutional year after year, Congress after Congress. You're dealing with the same jurisdictional problem. Notably, in this bill, this is where you start to see the overarching privacy, battle lines emerge or be expressed, and that is, this is a Democrat-only bill. There's no preemption. In other words, the bill doesn't have a provision that says the terms of this act supersede any state law. And there's also a private right of action. There's a provision that says you can sue if you're an individual and aggrieved by a violation of this act. And by the way, a violation of the act is an injury in fact, getting you past the first couple of stages of a lawsuit, or first stage. And there are monetary penalties, which is sort of what you see with Americans with Disabilities Act and the Telephone Consumer Protection Act, both of which created private rights of action in federal law that have created a lot of opportunities for trial attorneys to sue and sort of make a business out of settling. So there's a balance that policymakers are trying to strike, where they are giving individuals the ability to vindicate their rights while not overdoing it. And so the private right of action is something that Democrats have insisted on in Congress. And the lack and not preempting state laws is another thing that Democrats have insisted on, and Republicans have insisted on the opposite. And that has created that disagreement over those two provisions has created more roadblocks than anything else on privacy. So here is the Republican version of the contact tracing bill. The covered entities are not public health authorities; they are just the app developers. Plus, and this is a weird vestige of the FTC Act. The Federal Trade Commission Act does not cover nonprofits. It also doesn't cover common carriers like Verizon and AT&T. So this bill says anything under the FTC's jurisdiction, plus nonprofits, plus common carriers. So it would cover those. And I think universities have developed contact tracing apps, at least on a test basis. And so there you would at least bring in those. And so as a result, Commerce Committee maintains jurisdiction of the bill, increasing its chances, I guess, of being considered. Although now the Senate has flipped to Democratic control. And so there's going to be a lot of intrigue in terms of what happens there. But again, covered data does not include de-identified data, not reasonably linked or linkable to an individual. That's interesting because the other approach in these contact tracing bills is to provide that data is not de-identified unless it's not linkable to a device. And there, because a lot of contact tracing exposure notification apps depend on the random rotating identifier Bluetooth API from Apple and Google, potentially that identifies a device, even though it's a random rotating identifier. And so then you sweep in all of that activity into the requirements in the bill. Let's see, chat. Oh boy. Might take a minute for me to read. I'm not a fast reader, I'm sorry. I will come back to that. Let's see. This is the third one. This is a bipartisan bill, actually. Not only that, it was introduced by Senator Cantwell, was the lead. Senator Cassidy, you've seen him on the Smartwatch Data Act. Senator Cassidy is not on the Commerce Committee, but Senator Cantwell is now the chairwoman of the Commerce Committee, or will be as soon as they pass the organizing resolution in the Senate, and things get finally on track to start working again in the Senate. She will be the lead of that entire committee. And so her bill matters quite a bit. This is it's kind of a hybrid approach. So covered entities do not include public health authorities. It would just regulate the apps plus common carriers and nonprofits. It restricts processing and transfer of data, and it provides that no commercial purpose is allowed. So it's kind of the more restrictive one of the three. Let's see here. They also exclude de-identified data, and then it splits the difference between those two really controversial things I mentioned: preemption and right of action. There's no preemption, and there's no private right of action. So this is kind of a watershed moment, I think. It's just in a contact tracing privacy bill, but it is indicative. Like this is a watermark, I think, that signifies coming together on something that previously was not something that could have been dislodged. But like the Republican bill and the other Democrat bill, it enables state attorneys general to enforce the provisions of the act. Let's see if I can get to that question here. Oh, which part is a watershed? I can answer that. The fact that a Democrat-led bill does not have a private right of action, and it's a privacy bill that amends the FTC Act. So it's a generally applicable, the general economy. And the fact that it does not have a private right of action was a major step toward the middle, I guess, or step to the right from the Democratic perspective. It also doesn't have preemption, which is something that Republicans have insisted on, and the U.S. Chamber has insisted on. Our member companies think that preemption is important in the privacy context, just because you have so much going on at the state level. They're worried about having to comply with a big patchwork of state requirements. So there is a lot that sort of is riding on that determination, I think, from the App Association perspective too. Let's see here. Yes, that's a really good question. So the question here is, any info on how contact tracing data is protected in practice? And if different states have different, sets of requirements. And so if you're being asked by a contact tracer and that, about other people's, and the response to the contact tracer's question requires you to share other people's protected health information, that is a great question. And I think that part of it might be outside the scope of what those bills are trying to do, but really good question nonetheless. And I think that would be covered under the state's mini HIPAA requirements, and it would be dealt with that way in terms of what the patient, says about another person to the contact tracer. And I know that there are also state level requirements on government. So state governments are under even yet another set of privacy requirements. The big federal law is the Privacy Act of 1974, which binds federal agencies, and I think that states have their own versions of those that apply to state agencies, state governments. So that probably is what we're talking about when you're talking about a contact tracer calling. In terms of the contact tracing activities that apps are doing, and the data that is collected through an app, I'm not aware of a state that is not using the Bluetooth-enabled Google Apple API. Of the ones that are using contact trace or exposure notification apps, and so the way that works is that it enables devices to, let's see here. All right. So there were two, I mean, early on back in April and early May, as states were starting to think about like, how are we going to use smartphones to help us do contact tracing? They were looking at options that involved A, location data, and B, no location data. And the options that involved no location data were really just using Bluetooth beacons. And so the Google and Apple got together and they said, okay, most of the smartphones that people have in the United States are either on the Apple operating system or Android operating system. And so if we band together and provide an API, then we're going to cover, most people that want to opt in to such contact tracing capabilities. So they enabled the ability for apps to make use of Bluetooth enabled exposure notification, where if you are near another person's Bluetooth and person B has uploaded information indicating that they have a verified positive test for COVID-19, and you're around them for a certain amount of time in a certain proximity, then it will send you a notification. You have experienced an exposure. And it's been, so the way that data has been protected is that anybody that hasn't been subject to or hasn't uploaded an a verified positive test, all the Bluetooth indicators, the numbers that are associable with that device are only on the device, and they're only matched against other people's and downloaded to another server if there is a confirmed positive test and exposure. And even then, it's only the random identifier that's sent to the server. And so my understanding is all of that is also encrypted. And so the way it's protected is that it just lives on the device, unless and until there's an exposure, in which case it is transferred encrypted to a server, and then it is an identifier that is associable with the device, and that it's on the server. Which server, I'm not sure, but the idea is that by minimizing the data, you don't have to do a whole lot. The state public authority doesn't have to do a lot to, on its own, protect the data, because it's not hanging on to it, at least not the exposure notification aspect of it, the automated exposure notification aspect of it. If it were collecting location data, then you would have a richer data set, and you would be able to say, oh, you were at the grocery store when this happened. Oh, you were at you were at the vet when this happened. States have decided not to go that way for the most part, just because of the privacy implications. And then there was another question: what is a state-specific mini HIPAA again? Those are laws that are just kind of add-ons to the requirements of HIPAA that are supposed to apply to that are supposed to be coextensive in terms of their scope with covered entities and business associates. So I think there was a law in Massachusetts that was passed in 2018 that imposed another requirement on insurance providers to only provide data or certain information about a patient to the patient rather than the policyholder, which was an add-on to HIPAA. So that's what I'm referring to when I refer to mini HIPAA state laws. It's just the add-ons that are allowable, because HIPAA does not explicitly preempt beyond what it does federally. I agree with this comment that there's a comment here that it seems like a waste of time to craft contact tracing bills by the time they're enacted. I agree. I think there was sorry, I agree in part. I think it's a worthwhile exercise for policymakers to try and respond to this. I think it's maybe a too little too late. Like, I think what Congress realized was, oh no, we really should have had a federal privacy law in place of general applicability. Then there wouldn't be this trust gap that people are experiencing when they're being asked to download a contact tracing app and they're saying, the FTC Act is supposed to protect me, in this scenario. And so they're sort of reacting. But they have spent a lot of time. It's one of the only privacy bills that's been reintroduced to this Congress was one of the contact tracing bills. So they're spending time on it. And it's also a test case for some of those things and that have gotten people stuck in the past, such as private right of action preemption. So it's another way that those things are being expressed and hammered out. Good comment there, though. You're not wrong. Denny,
from their lips to God's ears, I would say that we don't have to find ourselves in contact tracing predicaments again. But
knock on wood.
We don't know.
I think that some people are also might be being either overly optimistic about how long the pandemic will still be an issue, or overly pessimistic over how long it takes to pass legislation. I'm not sure which.
Well, it can happen really fast, fortunately and unfortunately. Congress seems to be legislating by omnibus these days, and there were a bunch of things that passed along with the thing that was enacted back in December that made your head spin. There were a bunch of provisions that didn't exist until a couple months before they were enacted into law. So, I mean, it can happen fast. I mean, just not always the way you want it to. The privacy bills of general applicability are really interesting. They're really long, wide-ranging bills that try to account for a lot of different potential privacy harms and a lot of different sub-industries and industries that are under the FTC's jurisdiction. Interesting just to note a couple of aspects of each of these bills. So the first one I have on here is the main Republican privacy bill. Senator Wicker was chairman, or technically is still chairman of the Commerce Committee, and so his bill was the one kind of we were waiting for the introduction of. There was a draft of it floating around for months, over a year. So how does it deal with where HIPAA meets FTC? So what it does is it provides that if you are compliant with I think what they mean to do is if you're compliant with HIPAA as a business associate or a covered entity, you're deemed in compliance with our big general privacy bill. That seems to be great, but of course, the catch is if you're out of compliance with HIPAA and you're hit with a fine, then you are also subject to the terms of the general privacy bill. So double jeopardy attaches, I think. So you are liable under both regimes. And I don't think that's what they're trying to do. Maybe it is, but that was one of the things that we pointed out. And it is a feature of, I think almost all of the privacy bills of general applicability that are out there. If you're legitimately trying to comply with HIPAA, but you're out of compliance with it, the FTC has concurrent jurisdiction over a lot of those companies, and so could come after you, which is not good. Just like almost all of the other privacy bills that are being introduced and privacy regimes out there, it's really based on consent, which a lot of privacy advocates say is just an outdated way of doing it. And Naeem has articulated some reasons why there are serious limits on consent, including does the consumer know what they're signing up for? Nonetheless, it is one of the proxies for ensuring that the ownership somebody is supposed to have over their own data is expressed. So The healthcare data definition is interesting. It's any covered data that describes or reveals the diagnosis or treatment of the past, present, or future physical health, mental health, or disability of an individual. This is narrow because it is data that describes or reveals the diagnosis or treatment. There has to be diagnosis or treatment that's tied to. So I think that's notable, and I mentioned this is the Republican bill, and their purpose is always to very narrowly regulate, as narrowly as possible, impose requirements, even though it's a very wide-ranging and very regulatory bill. That what they're trying to do is limit healthcare data so that it doesn't go beyond what they mean to do, for what it's worth. And so the Democratic bills do something a little bit different. I don't think that's something that they would get hung up on. I think if they figure out preemption and private right of action, they'll figure out healthcare data definition. Small business exemption is there, as it is in most of these bills. It's a high threshold, so I think it's 50 million a year in annual revenue, but only from some of the core aspects of the bill and not from the rest of the bill. So there are things that a company will have to do in terms of responding to consumer requests, regardless of the size of the company. Risk assessments are a feature of this one, as they are a feature of almost all the other bills of general applicability. That's an interesting one because I think it contrasts with GDPR's blanket prohibition on processing data unless there's a lawful basis. Here, with risk assessments, what they're trying to do is say that if you fail a risk assessment, then that's something that you can't do. And so that's processing rather than the scope of consent, rather than consumer rights, things like that. It gets into limitations on processing, which is not something that was the subject of discussions when I was at the committee, and is a new thing, but it's, even Congress, even congressional Republicans are trying to deal with that. There is preemption. It is broad. States cannot enact general privacy laws, and it would preempt California. It goes a little further than California in a number of ways, but one way in which it does not go further than California is that there is no private right of action. And as we talked about with the contact tracing bills, state AGs can enforce it. So that's okay. Those are kind of the main features of the bill for this discussion. So the main Democratic response to this is COPRA. Again, Senator Cantwell, who now leads the Commerce Committee, and then you have Senators Markey and Klobuchar. How does it deal with HIPAA? Well, same way the Wicker bill deals with HIPAA. It says if you're compliant with HIPAA, you're deemed in compliance with our big general federal privacy bill. Again, that begs the question: if I'm not in compliance, and even though I've been trying to comply and I'm hit with a fine, now I can get hit with a fine from two regulators, unless something else is there. But it does say that Section 107 applies to HIPAA covered entities, and those are the data security requirements. Senator Cantwell feels very strongly about data security, and I think this is the exception to the general rule that nobody's trying to do anything, supersede or change HIPAA in Congress. This is the exception, is this Section 107. I didn't go into details on that. I just didn't have time to kind of put down everything that was in there. But if you want to check it out, S2968 from the 116th Congress, that's the last Congress. And it says that HIPAA covered entities, don't worry about this bill if you're compliant with HIPAA, except for Section 107. Section 107 applies, and those are data security requirements. Here's another thing that's in keeping with the theme: prior affirmative express consent for sensitive personal information, so opt-in for sensitive personal information. There's a broader definition than the Republican bill for health data, which is, again, a part of sensitive personal information. And that includes browsing history, email, phone number. Let's see here. Oh, sorry. Includes any information that describes or reveals the past, present, or future physical health, mental health, disability, or diagnosis of an individual. So the difference there is that there's not treatment or it's not tied to treatment or diagnosis. It includes diagnosis, but it's not limited to diagnosis or treatment and information that reveals that. So it's broader. There's a requirement for FTC rulemaking around the opt-out regime. The opt-out regime would be just for non-sensitive personal data, anything that doesn't meet the definition of sensitive personal data, which again includes health data, and is linked or linkable to an individual or device. So the small business exemption is it's a lower threshold. I think it's $25 million or, and the ors are, number of consumers, number of amount of revenue that is attributable to the sale of data. It's something that you see across a bunch of different privacy bills. But even though it's a low threshold, you're exempt from the entire bill. So the moment you get to that $25 million threshold or the other aspects of the threshold, all of it comes into force. Risk assessments, again, no preemption in keeping with the theme, and there is a private right of action. A violation of the act is an injury in fact, up to $1,000 per violation per day, and then punitive damages on top of that for negligent violations of the act, and then $5,000 for reckless or intentional. The last of the congressional proposals on general privacy is the staff draft from Energy and Commerce. The relationship to HIPAA is left blank because it's a staff draft. They left a lot of stuff in brackets. They left preemption in brackets. They left the relationship to other federal laws, including HIPAA, in brackets. This is a really outlier bill because consent may be implied for the processing of non-sensitive personal data, so long as it's consistent with consumer expectations. That's a really interesting way of going about it. But I think what they're responding to is all of the literature out there and all of the advocates that have been saying consent is has proven inadequate to the task when it comes to an expression of consumer best interests. And so they are trying to respond to that bipartisanly. Let's see here. The health information goes with the broader construct, and then the small business is interesting. There's a small business carve out, but then there's also a certified compliance program, which we liked at the App Association because it gives the ability to certify compliance via a third party, and they do this with COPPA, not very well, but they do it. A third party can certify your compliance, and then you're not directly liable to the tune of all the hefty civil penalties the FTC would have at its disposal under the Act, so long as you have that certificate. And that's up to $25 million a year threshold annual revenue. So, the question, does implied consent mean somebody can't opt out? No, it doesn't mean somebody can't opt out. Somebody could definitely opt out and have the company stop the processing of that data for sure. Any of those companies that are subject to the Act would also be subject to the requirement to respond to those requests. And the implied consent is not a shield from that. It's just it's an attempt to try and define a lawful basis for processing that is not explicitly tied to explicit prior consent. That's that with that bill. So here's a summary. So just to quickly summarize that, even under current law, we're going to see more data flowing outside the HIPAA covered umbrella. We talked about the information blocking rule. There's also the interoperability rules that were referenced. So there's a couple of different sets of rules that are kind of pushing us toward that new reality. The FTC under Democratic leadership is going to be more aggressive to enforce not only its UDAP authority, but also the health breach notification rule. It's also going to be pushing harder on Congress to develop general federal privacy framework that gives it general rulemaking authority, so that it's not just doing injunctions and settlements all the time. And then at the state level, with the perfecting amendments to California, we're in a slightly better place. We're probably going to see states enacting the Washington variant as well, which has a bunch of attributes that we like. We will see. The state legislatures are considering things right now. Virginia is one of them, where I live. And so we'll see what happens there. And I think pressure is going to just increase on Congress as states adopt slightly differing frameworks where all the compliance burden is not necessarily related to providing better privacy, but like just dealing with inconsistent state requirements. I think Congress is going to have to do something there. And then, the point we made earlier that Europe doesn't silo healthcare privacy from general privacy, although there are heightened requirements. And then Congress is active on privacy, but they're bigger in other fish to fry other than privacy, like Section 230 issues and related stuff, antitrust. Those will take precedence, but eventually come back to privacy, especially as we find ourselves in a new reality with state laws. And the preemption and private right of action still unresolved, even though you saw the movement on that one contact tracing bill. Let's see. So Naeem asked, do any of these bills define retention periods, say delete after purpose is achieved? Yes, they do. They take different approaches. Even just the contact tracing bills, one of them requires deletion 60 days after, or maybe it's 30 days after the expiration of the public health emergency. One of them requires deletion after 30 days after it was collected. That's a pretty strict one. So on a rolling basis, you have to keep deleting data that's contact tracing data. And then in the general privacy bills, there's a wider variety, I think, of the approaches to data minimization and deletion. I don't remember off the top of my head all the different ways that they approach it, but there are definitely, like for example, where a company has to respond to a deletion request. The Republican bill in the Senate says you have to either delete or de-identify in response to that request. And so I imagine that the deletion requirement has that same sort of construct, but I'm not sure. Let's see here. Another question, are there different rules for third-party apps under the control of patients/members? So CMS patient access APIs versus third-party apps like Smart on Fire that interface with providers/EMRs, but are still outside of HIPAA. I may have to get back to you on that one, unless Denny has some insight.
No, I think that's an open question. It's a very tough question, and I think we need to do some research on that. There are in the interoperability rules, the introduction of technologies that sit above the electronic health record and transport information from the electronic health record to, for example, a health plan, or allow a provider to answer a series of questions that come up on an applet, but Smart on Fire being, the programming language used to create these apps that are integrated with electronic medical records, among others. But it's a big question. We don't have an answer to that yet, but it's one that we will take offline and review and give our best shot at based on what we know.
That sounds good. I knew I was going to get one that just stumped me. That's a great question, though.
I'm good at that. Don't worry.
Good. God, I'm in good company.
Yeah,
Good.
yeah. And this is Naeem again. On this issue of fire and Smart on Fire and HL7 access perspective, I think a major challenge comes up is how you associate the consent with the data. And when data moves, then the consent moves. And the APIs and all those things have to bounce back against the consent and the data. Only that can be resolved. Otherwise, EMRs and all those things, they're basically using the security protocol, giving permission and not really what user permission. So that's where the entire the privacy management really relies on how effectively you manage the data and associate the data with the consent. And otherwise, when the data travels, so it should be part of the metadata, goes to a provider, to a radiologist, or some other, that attribute has to travel there, what patient has consented to be used for, or even X with the applications. So it's a bigger fish to fry in that kind of context. It's a lot more of data management issue goes back, and also the legal crosses the three boundaries. Anyway, so I'll stop here. Sorry.
Awesome. Thank you. I am continuing to learn. And there was one last question that we could cover. Oops, there it is. So the protection of minor consented data in conjunction with third-party apps and consents filed by a parent or legal guardian. So if you're talking about making data on minors available to a third party that's outside of HIPAA, the law that would apply to that third party would be COPPA, the Child Online Privacy Protection Act, and that presents a very weird question because under COPPA, that third party must have obtained verified parental consent, which is only achievable via limited means. So you have to have that parent's credit card information on file. You have to have, one way to do it is to have a call center where that parent answers a couple of questions that satisfies the company that they are the guardian of the kid. And so there are all of these verified parental consent questions that pop up. And the FTC is in ongoing rulemaking to modernize those requirements. We had some suggestions for them tied to allowing the platform company like the App Store or the operating system to assist with that and make it a streamlined process. I don't know where the FTC is going to land on that, but if what you're talking about is just parental consent given to the HIPAA covered entity, and then the HIPAA covered entity thereby being enabled and required to transfer that minor data, I suppose that's a question for HIPAA rather than COPPA, I think. And I don't know the answer to that. Yeah. Sorry.
Right now, I know that there are laws that differ from state to state regarding whether parents are even allowed to see their minor child's data after a certain age and who has the right to consent. So I like, it's kind of a mishmash from what I can tell. I haven't done a lot of research on it, but it's come up recently in a conversation that we had about consent. And so I would suspect that that's something where I think having some federal guideline or law or rule about exactly how that works would be really helpful.
Great, thanks. Thanks, Janice.
All right, we are coming up on the top of the hour, and I want to thank everybody for your questions. This was a terrific presentation, Graham. You maintained, for all intents and purposes, the entire audience from start to near finish, which I think is commendable, since many of our attendees book 90 minutes or 60 minutes, but you had an audience engaged for the duration. This is an extremely complex and evolving topic. We'd love to have you back as things evolve, especially or devolve, depending on what side of the aisle you sit. But where we can see what is happening in Congress and across the states with respect to privacy. It's changing. HIPAA is built on attestation, and now we're talking about consent. We're talking about a much more sort of individualized rather than enterprise approach to thinking about, how do you protect privacy and how do you distribute the responsibility for that? So on behalf of MHDC, our members and our guests, our community, we want to thank you for a terrific presentation and touching on a topic that obviously is of great interest to a number of us. And we will, follow up on questions that folks asked so that we can get back answers. Arlene and I will work with you to coordinate that. And we will also focus on getting you back to join us in the next 6 to 8 months or so, maybe towards the later part of this year, when the dust, hopefully, knock on wood, has settled on pandemic-related issues a bit, and have you back. So, Graham, thank you, and thank you to everybody who's joined us today. Stay well, be safe, and we'll talk to you all soon. Meeting is adjourned.
Thank you. Thanks, everybody.
Bye,
Thank you all.
everyone.